PB Road branch, Davangere. First, said check on presentation came to be dishonored with an endorsement. Insufficient funds. First, legal notice was issued. First, though legal notice is served, there is no complaints nor reply. Accordingly, complainant sought for action. Next, Alare trial magistrate took cognizance of the offence under section 138 of the Negotiable Instrument Act and secured the presence of the accused. First, plea was recorded, accused pleaded not guilty, therefore trial was held. In order to prove the case of the complainant, complainant got examined himself as PW1 and placed on record 13 documentary evidence which were exhibited and marked as Exhibit P1 to P13, comprising of dishonored check, bank endorsement, Vijaya Bank memo, debit invoice, bank memo, office copy of the legal notice, postal receipts, answered postal cover which was sent through RPD, and account extract. First, accused statement as is contemplated under section 313 CRPC was recorded, wherein accused denied all the incriminatory circumstances found against him. Next para. Accused also got examined himself as DW1 and placed on record copy of the FIR, which was subject matter of CC number 1528 of 2012, spot mahazar, seizure mahazar, copy of the property folio, copy of the charge sheet in CC number 237 of 2012, and copy of the list of witnesses in CC number 237 of 12. First, next para. Later on, learned trial judge heard the parties in detail and considering the rival contentions of the parties, after referring to the judgment of this court as well as the Honorable Apex Court, came to the conclusion that the defense evidence placed on record by the accused was not sufficient enough to rebut the presumption available to the complainant under section 139 of the Negotiable Instrument Act and convicted the accused for the offence punishable under section 138 of the Negotiable Instrument Act and imposed the fine of rupees 1,30,000 as against the check amount of rupees 80,000. First, in the said amount of rupees 1,30,000, sum of rupees 1,20,000 was ordered to be paid as compensation to the complainant and balance sum of rupees 10,000 to the defraying expenses of the state. First, next para. Being aggrieved by the same accused preferred an appeal before the District Court in Criminal Appeal number 86 of 2015. Next para. Learned judge in the First Appellate Court, after securing the records and hearing the parties in detail, dismissed the appeal by judgment dated 1st April 2021. First, next para. Thereafter, the accused is before this court in this revision. Next para. Shri Rajendra Reddy, learned counsel for the revision petitioner, reiterating the grounds urged in the revision petition, vehemently contended that the trial court grossly erred in connecting the accused in totally ignoring the defense evidence and the documents placed on record by the accused, which was subject matter of the criminal case proceedings. First, he also pointed out that the learned trial magistrate did not understand the presumption that is available to the complainant under section 139 in proper perspective and blindly accepted the case of the complainant, resulting in miscarriage of justice, and therefore sought for allowing the revision. First, he also pointed out, learned judge in the First Appellate Court, without even properly discussing the matter on record, blindly dismissed the appeal filed by the accused and thus sought for allowing the revision. Per contra, learned counsel for the respondent supports the impugned judgment. First, next para. In the light of the rival contention of the parties, this court perused the matter on record meticulously. On such perusal of the matter on record, the payment of loan by the complainant to the accused is very much stands established by producing Exhibit P13, which is the account extract. First, next para. On 2 occasions, the complainant has advanced the amount to the accused by checks. First, Learned counsel for the revision petitioner drew the attention of the court to the exhibits which were marked by the accused in exhibit D1 to D13. First, next para. Learned trial judge took into consideration the evidence of the accused in the rights perspective and discussed the same as to what is the effect of that evidence vis-a-vis the evidence placed on record by the complainant. First, next para. Learned judge in paragraph 14 of the impugned judgment has bestowed its attention especially to the cross-examination of DW1 and stated that accused has admitted that the address found in the exhibit P9 is that of his address and there was no compliance to the callings of the notice. First, why a person who has been served with the notice would keep quiet if the wrong claim has been made by the person is a question that remains unanswered and therefore discharge by the complainant was sufficient enough to raise presumption under section 139 of the Negotiable Instrument Act. First, further, the documents that are produced by the accused were pertaining to some other criminal case which had no bearing on the question of obtaining the loan and repayment thereof. First, therefore, the learned judge was justified, learned trial judge was justified in raising the presumption in favor of the complainant under section 139 of the Negotiable Instrument Act, and having noted that there was no rebuttal evidence, was justified in recording an order of conviction against the complainant. First, learned judge in the first appellate court also reappreciated the above factual aspects of the matter in proper perspective in detail in the impugned judgment. First, therefore, this court that too in the revision, cannot revisit into the factual aspects in upsetting the finding of guilt of the accused for the offence punishable under section 138 of the Negotiable Instrument Act. First, having said this, next. This court is of the considered opinion that awarding cannot be countenanced in law in view of the fact that the list is privy to the parties and no state machinery is involved. Accordingly, set sum of rupees 10,000 needs to be set aside. Hence, following order, revision petition allowed in part while maintaining the conviction of the accused for the offence punishable under section 138 of the Negotiable Instrument Act, the fine amount ordered by the trial magistrate is reduced from 1,30,000 to 1,20,000 and entire sum of rupees 1,20,000 is ordered to be paid as compensation to the complainant, failing which the accused shall undergo simple imprisonment for a period of 1 year. First, next para. The amount of rupees 10,000 awarded to the state as fine amount towards the defraying expense of the state is hereby set aside. Ordered according. Time is granted till 10/7 to pay the balance amount. 10/7/20. No,
4 weeks.
no. 2012 in the Indian month.
Sorry, too short. 4 weeks.
No time. Yes.
Number 31, Harish.
If you want 10/7 ಬರೀತೀನಿ. ಇಲ್ಲಾಂದ್ರೆ no time.
ಬೇಡ.
10/7. 2012 ಇದೆ ಅದು. ನೀವು ಕೊಡ್ಬೇಕು ದುಡ್ಡು.
Harish,
ಕೊಡ್ತೀವಿ ಇಲ್ಲ ಅಂತಲ್ಲ.
20 ದಿವಸ ಕೊಟ್ಟಿದ್ದೀನಿ, ಇನ್ನೇನಿದೆ?
ಇನ್ನೊಂದು 10 ದಿವಸ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
All right, 20th July. 20th July.
Please.
Number 31, Harish HV.
Appearing for the petitioner, Your Honor, the respondent has been expired, so filing an LR application.
Respondent complainant setter died and an application is filed for substitution. Issue notice.
Much obliged.
Devanand?
But this is a conviction.
Yes.
Been upheld by the first appellate court as well. Feel it, there is an ambience for me to stand before my lord to point out the judgments of both the courts or not. I could not read the papers fully.
But the court has read the papers.
Should I not assist the court?
You can see, ಇದು conviction ಆಯ್ತಲ್ಲ.
This is
The-
not under a POSCO Act,
No, 354.
354.
ಅದಕ್ಕೇನೆ 5,000 ರೂಪಾಯಿ ಫೈನು, 2 years imprisonment. ಯಾರವರು? ನಿಮ್ ಪಕ್ಕದ ಮನೆಯವ್ರೇನು?
Allah, he is, the accused is a karate teacher.
ಆಯ್ತಪ್ಪ, ಕರಾಟೆನಲ್ಲಿ ಅಲ್ಲೆಲ್ಲ ಬೇಡ ಬೇಡದ ಕಡೆನಲ್ಲಿ ಬೇಡದಾರ್ದಂತ ಮುಟ್ಟುವಿಕೆ ತಪ್ಪು.
That is a story that has been presented by the
Okay, it's
prosecution.
okay. Now the question is, who is the victim?
Victims are the minor girls according to the